My name is Nancy McKinney. You can see my photo. You can't see my me live, so sorry about that, but it doesn't matter because it's my pleasure as the CEO of Marin Humane to welcome you to our estate planning basics webinar. We hope you find the information presented today very useful and encourage you to ask questions, pose questions of Carolyn, our presenter, using the chat feature, because she might be able to help you with your estate planning questions. If you'd like more information about Marin Humane's Guardians program and the Legacy Society, I'll briefly talk about that at the end of today's webinar. And then at the very end, you're going to get a pop-up survey, and we ask you to take a few minutes to just answer a few questions and give us the feedback. We are recording this seminar, so if you missed anything, we'll send you a link so you can view this presentation later or share it with a family member or friend who might benefit from hearing about this information. And again, we have a Q&A. We have set aside time for a Q&A following Carolyn's presentation. So we'll be monitoring your questions as you put them in the chat box, and at the end, we'll go through them. Without further ado, I want to thank Carolyn Poppen for joining us today. If you haven't met her before, she's great and a wealth of information. Carolyn is a seasoned 20-year trust and estate attorney with offices located in San Rafael. Like all of us, Carolyn is also an animal lover and is the guardian of 2 dogs, Elkie and Colby Jack, and 3 cats, Princess Leia, Blue, and Echo. So welcome, Carolyn.
Thank you very much, Nancy. I am honored to be here today talking with you all about estate planning. It's not the most interesting of subjects, but it is certainly a very important subject. So I've peppered today's slides with some hopefully engaging photos to keep our audience along for the ride. I'm going to go ahead now and start with the screen share. All right, I'm hoping everybody can see what I'm sharing, and if not, please let me know. Either throw it up in the chat or just shout out. So today's presentation is entitled Estate Planning Basics. We're going to be talking about wills, trusts, and almost everything in between. Let's begin with an agenda. In today's presentation, you're going to learn what is an estate. You're going to learn what happens to your estate if you lose your marbles. Now, there's a legal term for loss of marbles. It's incapacity. It's a little bit of a mouthful, so you may hear me refer to it either as loss of marbles or incapacity today, but just remember, they're the same thing. You're also going to learn what happens to your estate when you die. And throughout the presentation, you're going to learn ways that you can actually plan for your estate. So let's start with the basic question of what is an estate and who has one? An estate is everything that you own, right? And it includes a lot of things that you probably would think would be in an estate. Things like a home, an investment account, a bank account. But in addition to those assets, there are other things that are in your estate as well that you might not readily think of. Things like your wine collection, your baseball collection, your photos, the stuff in your home. Even your pets are part of your estate. So everyone has an estate. The size may vary. Some folks have smaller estates, other folks have larger estates. But an estate is everything that you own. Let's talk about what happens with your estate during your lifetime if you lose your marbles. So we're talking about incapacity. And in this scenario, you're alive, you've lost your marbles, but you don't have any estate planning documents. So for example, you don't have a power of attorney or a healthcare directive or a HIPAA authorization or a trust. What happens to your estate in that situation? The answer is something called a conservatorship. Well, you may be asking yourself, what is a conservatorship? A conservatorship is an ongoing court supervised process. So it's overseen by a judge. And through the process, there is a formal determination that you have lost your marbles. So this is a little bit more than just, forgetting where you left your car keys or your glasses. This is a form of cognitive impairment, and it could be due to something like dementia or some other diagnosis. The purpose of a conservatorship is that it allows for management of your finances and your medical care by someone else. So you're being taken care of by someone else. What about the downsides to a conservatorship? Well, one of the big downsides is that the conservator, or the person who's handling things for you, has to hire an attorney. A conservatorship is not something that you can DIY or do it yourself. Okay, an attorney needs to be involved. And your estate, your money, is actually what pays for the attorney, not the conservator's money. And average attorney rates in Marin are anywhere from $300 to $700 an hour. And potentially the most important part of a conservatorship is that it's a matter of public record. So that means that anyone who knows where to look can find information about your private stuff that you may not want them to know. Well, you may be wondering how you can avoid a conservatorship. And there are several documents that will allow you to avoid a conservatorship. Let's talk about them. The first is a power of attorney for finances. And you may have also heard this called a durable power of attorney, or maybe even a statutory form power of attorney. This is a document that's effective only while you're alive. It doesn't give away any of your property. What it does is appoint someone to act on your behalf financially, so that if you lose your marbles, this person can step into your shoes financially and make sure that your bills still get paid and that your electricity stays on. That's one of the documents that can help you avoid a conservatorship. Another document that can help avoid a conservatorship is something called a healthcare directive. You may know this as an advanced healthcare directive. If you've ever lived in another state, you might have heard it referred to as a living will. Different states have different names. This is a document similar to the power of attorney in that it's effective while you're alive. Similar to the power of attorney, it doesn't give away any of your property. In fact, this document has nothing to do with finances at all. It has to do with your medical care. And in this document, you are appointing someone to act as your agent, act on your behalf medically, to make sure that if you can't take care of yourself medically, someone else can. So what that means is that person can assist with medication or treatment, or if you need assisted living. Those are all things that an agent under a healthcare directive can help you with. Working in conjunction with the healthcare directive and the power of attorney is something called a HIPAA authorization. Okay, HIPAA is a federal acronym that stands for the Health Insurance Portability and Affordability Act. And this document simply says that if someone is acting for you on your behalf, either financially or medically, that person is allowed access to your private confidential health information. Because under federal law, your health information is so confidential, it's not even supposed to be shared with your spouse. Or if you are a caretaker for older parents, without a HIPAA authorization, you're not entitled to information about how your parents are doing. And the final document that can help avoid a conservatorship is something called a revocable trust. I'm not going to talk too much about that document right now because I'm going to spend a lot more time later on in this presentation covering that. So just remember that that document is there and you're going to learn a lot more about it in a few minutes. It's time for a story. And before I tell you my story about conservatorship avoidance, I just want to let you know that this photo is actually a photo of 2 of our 3 cats. So Echo on the right and Blue on the left. This is a legitimate pet owner photo. I just had to put that plug in. So earlier in my career as an attorney, I had a client, and my client was concerned about her elderly uncle. So my client was the niece. She had an elderly uncle. She had learned that her uncle was having some problems. And when I say problems, that's a really nice way of saying he was doing some pretty kooky stuff, like answering the front door without clothes on, handing out money, cash or check, to anybody that showed up at his door. So not only were his neighbors who knew him concerned, but his niece, who was my client, was also concerned. And initially we thought that we might have to get her elderly uncle conserved in order to make sure that his niece had legal authority to make decisions for him financially and medically, because it was pretty clear to all of the outside people that the elderly uncle wasn't really doing so well. Throughout the course of our work, though, we realized that the uncle had years before put together an estate plan that included a healthcare directive, which named his niece, my client, as the agent to make medical decisions for him. We also learned that he put in place a revocable trust that allowed my client, as the niece and successor trustee, to step in and manage things for her uncle. So it worked out that this elderly gentleman didn't need to be conserved. But this is sort of a cautionary tale of what could have happened without the right estate planning documents in place. Next, we're going to talk about your estate and death. What happens to your estate when you die? And there are 3 options under California law. We're going to talk about each option in more detail. So the first option is when you don't have a will and you don't have a trust, what happens to your estate? In this scenario, California law decides, okay, there's another legal term for this situation. It's called intestate, but again, like incapacity, that's kind of a mouthful. So we're going to just think of it as no will or trust. The second option is when you have a will. So having a will, something is better than nothing, but having a will only is going to mean that your will is subject to probate. I'm going to talk about what probate is in just a minute. The third option for your estate at your death is if you have a trust. And a trust is designed to be privately managed. Before we talk about the options for what happens to your estate when you pass, let's make sure that we're all clear on the differences between wills and trusts, okay? So a will is a document that transfers property at your death. So it's not effective during your lifetime, right? A will doesn't have any authority until after you've passed. A trust is also a document that allows for you to transfer property at your death. But unlike the will, the trust is effective during your lifetime. So it can allow for management of assets in that scenario that we were talking about earlier, where you were alive, but you lost your marbles. So let's look at option number 1, which, as you may recall, you don't have a will, you don't have a trust, and California law decides. In this option, if you're married and you have what's called community property, which is property that you and your spouse have earned through work while you were married or things that you bought, then under California law, all of your community property is going to go to your spouse. But what happens if you have separate property? Okay, separate property might be property that you brought to the marriage. Maybe you owned a home that before you got married and you maintained that home. Maybe you brought a bank account to the marriage. Separate property might also be property that you received as the result of an inheritance, maybe from a relative, or something that someone gifted to you. Okay. In terms of separate property, If you're married and have no children, then 100% of your property goes to your spouse. But if you're married and you have one child, then your spouse only gets 50% of your separate property. You may ask yourself, well, where does the other 50% go? Well, that goes to your child. But let's talk about what happens if you have 2 or more children. In that scenario, where California law decides, then only 33% or 1/3 of your property goes to your spouse. The other 2/3 goes to your children. And if your children are minors or under the age of 18, then you're looking at a different court process called a guardianship, because under California law, minor children are essentially ineligible to receive their inheritance because they're too young. Let's talk about what happens in option number 1 if you're not married. Who inherits your estate then? Well, the short answer is it depends. And what it depends on is who's related to you by blood and living at the time that you pass. So it could be children if you had them. It could be parents if your parents were still living. It could be your siblings. But it also could be more remote relatives like nieces and nephews or cousins. Who inherits your estate is going to depend entirely on who's related to you by blood and still living at the time that you pass. Well, what about your pets? What happens to your pets under California law? Unfortunately, California law at this point is pretty much silent on pets. So what that means is that your loved one, your animals, are dependent on someone volunteering to take them, to be responsible for them, potentially to use their own money to care for them. And that may not be something that you're comfortable with. The important thing to remember about option number 1 is that it's not automatic. None of those transfers of property just happen, right? The court has to get involved to oversee it. It's time for another story. And the title of this story is No Will. And this story is based on an actual case that I currently have. And in this story, my client is the mom. My client is a senior citizen. And we are administering or handling her son's estate. Her son died unexpectedly and quite tragically at age 40. He didn't have a will. He didn't have a trust. He didn't leave anything behind except a lot of debt and 3 little kids who lived with his ex-wife. My client and I started working together in the fall of 2021. It's now May of 2023, and we are still working to clean up her son's estate. And it's a really sad story because this situation didn't need to happen. There are things that her son could have done, even as a vigorous, healthy 40-year-old, to avoid the heartache that she and her grandchildren are going through in order to wrap up his final affairs. Moving on to option number 2, you may recall that this is the will-only option. And I said earlier that having something like a will is always better than nothing, right? Gets you a step above California law deciding, and it allows you to make some decisions about who gets what and how do they get it. But like option number 1, having only a will, it's not an automatic transfer. So, for example, if my will says I give my Wells Fargo account to my best friend, that doesn't mean that my best friend simply takes a copy of my will down to the local branch of Wells Fargo and she gets my account. That's not how that works. In order for my will to be proved valid and for someone to be appointed as the executor, there's a process called probate required. Okay, probate, like a conservatorship, is a court-supervised process. That means a judge is involved. Like a conservatorship, it's a matter of public record, right? Anybody that knows where to look can find out information. Probates take a long time, typically 12 to 18 months. And one of the biggest deterrents to probate is that it's expensive. And so let me explain how the probate fees work. Probate fees are set by statute. So that means that the legislators of the state of California have decided how much it should cost to probate an estate. How much it costs is dependent on how big the estate is. So the bigger the estate, the more it's going to cost. But if we quantify that, let's say that your estate is worth $500,000 because you have a bank account and a home that you bought, home in Marin County that you bought a long time ago that's appreciated and that is now worth a lot of money. If your estate is worth $500,000, your estate can expect to pay $13,000 in attorney's fees to someone like me simply for preparing the documents to go through probate. The person that you appoint as your executor is also entitled to get paid. Being an executor is it's a heavy side hustle. It's kind of like a part-time job. So the executor is entitled to get paid the same amount as the attorney, $13,000. And in addition to that $26,000 in fees and commissions, there are court fees because there are things that have to be paid for. And every time someone appears in court, you pretty much have to pay for that privilege. So that's an additional $2,000. That's $26,000 that's not going to your people or your charity or to take care of your pets. It's not going to cost you $26,000 to put together an estate plan that's going to keep you out of probate court. One of the benefits, though, of at least having a will is that you can provide or decide for your pet, right? You can put some provisions in place and allocate some money to take care of your dog or your cat. Now, there are two different kinds of wills. The first kind of will is what I call the regular will. Okay? A regular will can actually be handwritten. Yes, you heard me right. California law does recognize handwritten wills as long as you date it and sign it and your provisions are clear. A regular will can also be something that's prepared by an attorney. And in a regular will, you are disposing of your property. You are giving a person or a charity a specific thing or maybe all of the things. Okay. The important caveat of a regular will is that it gives something directly to someone. Contrast that with the other kind of will, which is a pour over will. This type of will is typically prepared by an attorney, so it's not something that you do yourself. It's typically part of a more comprehensive estate plan. And a pour over will disposes of property to a trust instead of to a person or charity. So in that example that I gave you earlier about giving my Wells Fargo bank account to my best friend, if I have a pour over will, my will is going to say I give all of my property to the then serving trustee of the Carolyn Poppin Trust. It's time for another little story. And again, it's a cautionary tale. This story is entitled Only a Will and No Will. So this story begins with an older man who read a will. And his will said, I give my interest in this family business to my sister. Okay, pretty straightforward sounding. My client is the niece of the man who died. And so we are in probate in Alameda County to handle her uncle's will. Now, the gift of that interest in the family business to the sister, unfortunately, the sister died about 5 months after the uncle died. And so she lived long enough under California law to receive the interest in the family business, but it wasn't actually distributed to her because the probate was still ongoing. And the sister who died had a trust, but she didn't have a will. And because she didn't have a will and she hadn't yet received the interest in the family business to put it over into her trust, my client is now doing a second probate for the exact same asset in a different county. So this is a story that could have been better if the sister had had a pour over will, and if the uncle who was making the gift initially just had a trust. Let's talk now about option number 3, which is you have a trust. And before we dive too deep into trust, let's cover some important definitions. So first, a trust, as I mentioned earlier, is a document that gives property away. But in a trust, you are creating what's called a fiduciary relationship, where there's a person who's called a trustee in charge of assets on behalf of another person who's called a beneficiary. Okay. And some trusts are created such that the person who made the trust, which is called the settlor or the trustor, sometimes the trustor, the trustee, and the beneficiary are all the same person, but sometimes not. Let's talk about the kinds of trust. There are essentially 2 kinds of trusts. For purposes of today's presentation, I'm going to be focusing mostly on revocable trusts. You may have heard the term revocable. You may have also heard revocable living trust, inter vivos trust, grantor trust, living trust. All of those mean the same thing. They mean a revocable trust, and a revocable trust is a trust that can be changed. Okay? It can be changed a little or it can be changed a lot. The other kind of trust is something called an irrevocable trust. Unlike the revocable trust, this type of trust cannot be changed. So you may be wondering, what can a revocable trust do? Well, revocable trust can save your estate money, it can save your estate time, and they can certainly save your estate hassle. Because if you remember from the earlier slide, a trust is allowed to be privately managed, and a revocable trust can avoid a conservatorship proceeding where you were alive, but you've lost your marbles. It can avoid a probate proceeding for transfer of assets at your death. And a revocable trust allows you to transfer all of the things. So homes, bank accounts, investment accounts, antiques, jewelry, artwork. It allows you to transfer all of those things to the charities or the people that you choose. It even allows you to financially provide for your children and your pets. So let's talk about trusts for children. These types of trusts are typically created within the revocable trust. Typically, these kinds of trusts are not activated or created until the person who made the trust dies. And a trust for a child or children can hold money for the child. Typically, there will be a trustee who is not the child that's in charge of the money. The trustee has discretion to use the money in the child's trust for things like health, education, maintenance, and support. These terms are usually generally defined so that whether your child goes to parochial high school or college or vocational school, all of those are covered under the definition of education. If your child needs medical insurance or orthodontia, those would be covered under the definition of health. Okay. In a trust for a child, you, in addition to giving the trustee discretion to use the money for your child, you can say, trustee, you shall give some portion of this trust to the child at a certain age. And that might look like some part of the child's inheritance at age 25, maybe more of their inheritance at age 30, maybe the remainder at age 35. Those are all things that you as the person making the trust get to decide. So working with your trust and estate attorney, you can determine what makes sense for you, your family, your children, because trust planning isn't a one size fits all. Okay? And typically trusts for children end at what I call the magic age. And that magic age is going to be different for every family. Some trusts for children end on the early side, maybe age 25. Other trusts for children end a little bit later, like 40. And there are trusts for children that can exist for the duration of the child's lifetime. We've talked about trusts for children, and this presentation is from Marin Humane. Let's talk about trusts for pets. Yes, you can have a pet trust, and a pet trust is very similar to a children's trust. Like a child's trust, it's not effective until the person who made the trust has died. And typically in a pet trust, the trustee is holding money for the benefit of your pet. And just as a reminder, unfortunately, Marin Humane cannot be your trustee of your pet trust. You're going to need to work with your trust and estate attorney to find someone else to fulfill that role. In a pet trust, you also can name a custodian or a guardian. And this is the person who would actually be responsible for the physical care and custody of your pet. And their job would exist for the remainder of your pet's life. You may be wondering, who can have a pet trust? Well, pretty much any animal can have a pet trust. And of the list of the 6 different animals on the left-hand side of the slide, I personally have done pet trust for the first 4. So dogs, cats, horses, and turtles. You may be wondering what happens if my pet dies before me. So I've created a pet trust, but what if my pet doesn't outlive me? In that scenario, then your pet trust is not created. Instead, the money is going to go somewhere else, as you've already decided, right? You're going to talk with your attorney about the alternate distribution. So if your pet doesn't survive, where does the money that you earmarked for them go? You may be wondering, well, what happens if I get a new pet, right? So at the time that you write your trust, the time that you set up the pet trust, you don't yet have the animal that's going to benefit from the pet trust. If your trust is properly drafted, then it's going to be inclusive enough that even if your cat Muffy isn't living, but you get a new cat named Tabby, Tabby's going to be included in the pet trust. As Nancy mentioned earlier, she's going to be talking about the Marin Humane Guardianship Program. So that's another option to having a pet trust. As we wrap up, let's talk about what was discussed and what you hopefully learned during this presentation. You learned what is an estate. The short answer is it's everything that you own. You learned what happens to your estate when you lose your marbles or die. The short answer is it depends on your estate plan, specifically whether or not you have an estate plan and what kind of estate plan you have. You also learned how can you plan. The best way to put together an estate plan is by talking with a trust and estate attorney, someone like me, that can help you decide what you need and can help you make the big decisions about who does what for you financially and medically, and who gets what when you're no longer with us, and how do they get it? This final slide is a picture of my corgi, Colby Jack. It also contains my contact information. By virtue of attending this presentation, I would invite you to contact me, schedule a complimentary 20-minute consultation, no charge to you, to talk about how we might work together in order to create the best estate plan for you.
Thank you so much. We have a few questions, but I want to just touch upon just briefly what we can offer for those who might want to consider making a gift to Marin Humane. And we just have one slide that we have a program called the Legacy Society, and that is for anyone who designates a gift in any amount to Marin Humane. And we also communicate and regularly have functions or webinars like this for our members of the Legacy Society throughout the year. So it's nice to meet people and be able to be a part of Marin Humane during that time. So we have that. Then if you're part of the Legacy Society and you have an animal that you are pets, are turtles, like Carolyn said, she worked on the care for a turtle with a client. This gives this exclusive benefit allows members to register their beloved companion animals, family members with Marin Humane to ensure that we will care for and place in a new home it should the guardian no longer be able to provide for their care. So lots of information, happy to help out. And if you're interested, please contact Nan Zimmerman, who's on our team in our development department, and she's left her email and phone number on the screen. So happy to help and follow up with any conversations. And again, valuable information. And some of the questions came in, Carolyn, I'll just, what kind of life events, someone asked, might trigger the need to update your trust?
So those kinds of life events might be someone has gotten sick or died. Maybe they moved away. Maybe there's been a change in the relationship. You don't like them anymore. I always tell my clients, look, you file your income taxes every year. I don't recommend you read your estate plan every year, but at least hit the high points. Look at who did you pick to do something and run through the list. Do you still like them? Are they still healthy? Did they move to Australia? And then look at the question of who gets what, and does that still make sense? So, any of those factors might be an opportunity to revisit your estate plan. In addition to those, certainly changes in your net worth. You get a windfall of money or you lose a lot in the stock market. Changes in the estate tax law. Those would be opportunities to talk with your trust and estate attorney about your estate plan. Does it still work? Does it still make sense? And do you need an update?
Good. Another person asked what is the difference between a revocable and irrevocable trust?
Sure. So a revocable trust is a trust that can be changed. An irrevocable trust is a trust that's locked in, meaning there's no ability to change it. Most clients in California are looking to put together revocable trusts because they want the flexibility of being able to change their trust in case something in their life changes. Maybe the kids get older, or maybe they haven't been philanthropic and they suddenly want to be philanthropic. Typically, people that are doing irrevocable trusts are doing it as part of some very sophisticated estate planning, and they're worried about paying estate tax at a federal level and trying to minimize that.
Those would be the benefits to thinking about irrevocable trust if you had that type of estate or wanted certain benefits in the tax.
Yes.
We have a parent who has asked, do I need to update my trust once all my children are over the age of 18?
The answer to that is it depends. Assuming that the trust was properly drafted, there's probably a mechanism in the trust that now that the children are over 18, their inheritance is sort of described, right? Maybe there were children's trusts that existed. I would assume that that's the case, but unfortunately, without actually seeing the document, I can't say. I can tell you that if I drafted your document, the fact that your children were 18, 40, or 50 wouldn't make a difference. There'd be a clear succession of who got what and how they got it. And just because someone got older wouldn't necessitate changing the trust.
Mm-hmm. Is there a website that shows how each state's laws impact estate planning and what the laws are specifically?
Not that I'm aware of. So the United States is a collection of states, and estate planning is very state specific, meaning what we do in California, I know from experience, is not what they do in New York. So you would make your estate plan based on the state that you actually live in, right? As if you're a resident of Marin County, California, you're a California resident and you would have a California estate plan. Now, if you're a California resident but happen to own, maybe you own a condo in Florida, and I've had clients that have been in this situation, then you can include your real property in another state as part of your California estate plan because you live here. So you can bring in assets from other states, but what I generally don't recommend is having a California estate plan and then moving to Florida and not doing anything, right? That's a recipe for complication, and complication usually leads to additional expense and someone needing to go to court to get a court order to figure something out. All of that's avoidable with a properly drafted trust.
You might have covered this already, but a twist on the question about how often should someone update their estate plans and what are the benchmarks for those updates? Just making sure.
Yeah, there's been a number of changes in the tax law lately, at least over the last 10 years. We're on our 4th iteration of a tax law. So certainly changes in the tax law are opportunities to revisit your estate plan. But at a personal level, just changes in your net worth, changes in maybe you picked your sister to be a successor trustee and an agent under your power of attorney, and your sister isn't unfortunately passed. That would be an opportunity to consider updating your estate plan. Similarly, if you had an estate plan that you drafted, 15 years ago when your children were really little, and now you have college students, that may be an opportunity. There's not a hard and fast benchmark for when you should update your estate plan. But I tell clients, anytime that there's a significant change, a birth, a death, a marriage, a fallout with someone's moved away, those are all opportunities to look at your plan and ask the question, do we need to make an update?
Any tips or advice on selecting your executor of your estate or the trust?
That's an excellent question. I'm so glad someone asked that. So contrary to popular opinion, your executor or your trustee doesn't need to be like a professional. They don't need to be an attorney or a financial advisor or an accountant. What you need in selecting a trustee is you need someone that's cash register trustworthy. What that means is that someone who is going to follow what your trust says and is honest enough to do the right thing. Because that person is going to get legal advice from an attorney. They're probably going to talk to your financial advisor. They're probably going to work with your CPA. So really the threshold requirement is, do you trust this person? Are they going to say, I'm honored to have this job and I'm going to do this because this is what Nancy wanted. This is what Nancy wrote down. That's really the minimum requirement. And who is the best trustee really depends on the client. I see a lot of clients that pick family members, right? They have a large enough family that there's someone of their generation or a younger generation that it makes sense. I have other clients that say, I don't want my family anywhere near this. Okay. And so that's a different conversation. And that situation, then they might be using something called a private professional fiduciary. That's someone whose job it is to be the trustee. Or maybe they're using a corporate trustee, like a bank or a trust department. Again, estate planning is not one size fits all. So that would be an excellent conversation to have with your trust and estate attorney, because where I've seen plans fall apart is when the clients weren't honest with themselves and they weren't honest with their attorney. And there's a case from way back when I first started, and it was, brother and sister, dad died first, and then mom died. And my firm represented the trust after mom's death. And these were two siblings who just hated each other. And the distribution of the trust was even. I mean, they were both treated fairly, 50-50 split. But the problem was the parents put these two siblings who could not stand each other as co-trustees. And it was really like, and my firm watched these people spend tens of thousands of dollars fighting over stupid little things like the out of tune piano that was worth $0. So, that's an example of that wasn't a good plan. If that had been my client, we would have been really talking about how can we make this plan better? Because ultimately what happened in that case was, eventually the brother and the sister got their 50% of what they were supposed to get, but what they received was a lot less because so much money had been spent on attorney's fees that if someone else, Uncle Sally or, the bank, if somebody else had been the trustee, they wouldn't have been fighting.
So hypothetically, let's say you recently moved to California, had your estate plan in another state that the attorney says, well, you're in California, so you have to use someone in California because they don't practice. And you're about to pick an attorney to help you. What should the client do in that first meeting? What helps you when you meet with new clients to set things up? Is it you have a survey that we fill out and we have a conversation? Do we bring our paperwork to the first meeting? What's a typical start to meeting with an attorney to talk about these things?
So it's going to depend in part on the attorney that you select. I can tell you what I do in my practice. So my practice starts, the first conversation is just, it's a complimentary consultation. It's 20 minutes to sort of get acquainted. We can do it by phone, we can do it by Zoom. And it's just, for me to explain how I work with clients and to sort of answer some general questions. Most of my colleagues, myself included, have an estate planning questionnaire. And so that's the document that would be typically distributed after that consultation. And it collects more information about who you are, what you have, and what you're thinking about in terms of who does what financially, medically for your kids and your pets, and who gets what and how do they get it. So you would complete a questionnaire, and then there would be another meeting. Usually that's a design meeting that's a much more in-depth. Okay, these are the documents that are recommended. These are the problems that I see based on your questionnaire. My questionnaire is only 6 pages. And I always tell clients, it's not intended to be homework, but it's just to help get you thinking about things, because this is a conversation and a dialogue. I have clients that have much more detailed questionnaires. So, it's really going to depend on the attorney, but usually that very first contact, you might be talking with an assistant to schedule an appointment, and they should be telling you what's expected in terms of any documents that you might need to bring. If the client has documents from another state and they say, we don't want to make any changes to who does what or who gets what, we just want to make it California law compliant, that's going to make it a lot easier, right? As long as I can look at those documents and go, oh, Susie, Johnny, and Tommy are still the people to do things. That's great. We're going to sort of take that information and we're going to sort of put it into California documents and take what the client's already decided on. So it's going to streamline the process from someone who's just starting at the very beginning, doesn't know what they need, is making the decisions about who does what, who gets what, and how do they get it.
Okay, just reminding people, if you have any last questions, put them in the chat. I only think we have one left. And the person's asking, what would it cost approximately to set up a trust in Marin County?
So the answer is going to depend on whether the attorney that you're working with charges hourly, meaning for every hour that they work, they're billing you for that time, or whether the attorney works on a flat fee. In my practice, for clients that are just creating their first time estate plan, usually that's a flat fee. I don't know what my colleagues are charging, but I can tell you what I charge. So for a single person comprehensive estate plan, including a trust and a whole bunch of other documents, so that that person is prepared regardless of what the emergency is and regardless of when the emergency hits, my price point starts at $3,500. For a married couple, the flat fee is $4,500. You may find other attorneys charge more. You may find that other attorneys charge less. I think based on my experience with colleagues in other counties in the Bay Area, Marin is a little bit more reasonable. I know attorneys in the South Bay, like Silicon Valley, that are charging, $5,000 for a single person plan and $7,000 for a married couple plan. So in terms of selecting the attorney, and I know, Nancy, this wasn't a question that was asked, but I feel like it kind of dovetails perfectly to what I was talking about, is in selecting an attorney, pick someone that you feel comfortable with, right? This conversation about being alive and losing your marbles, about what happens when you die, it's not easy. It's difficult. And some of the work that I've done, I've seen breakdown. When there's a breakdown in communication, because the client didn't feel comfortable asking the attorney, or the client was worried they were going to get charged for asking the attorney, that's what leads to problems. When the clients think, oh, my plan says this, And then I look at the plan and I say, well, that's not exactly what your plan says. And they're surprised. And it's because they didn't have that relationship, right? I mean, this is a trust and estate attorney is a trusted advisor. So you want to work with somebody that you feel comfortable with, even if they're, not the cheapest, or maybe they are the most expensive, but select somebody that you feel comfortable with. I would say select someone that focuses solely on trust and estate planning, right? You don't want a general practitioner that does a whole bunch of stuff. You want somebody that's focused on trust and estates. And, you can also hire certified specialists that are specialists in trust and estates. So there are a lot of options. There are a lot of competent attorneys in Marin. I would just encourage the audience, if you're looking for an attorney or trying to suggest an attorney to someone that work with somebody that you can communicate with and that you trust.
That is very valuable. I was going to ask you that question about selecting and finding, and how do you make those decisions? So I think we're towards the end. We have a few minutes left. And so what we're going to do is say thank you to everyone who participated. Thank you, Carolyn, for all that information succinctly and within an hour. And lots of information for us to take back and think about our situation. Again, the way you talked about the wills versus the trusts, that got me thinking about some things that I need personally to think about, given you can probably hear my whiny dog in the background here. So anyways, thank you very much for participating, and attendees. Again, we are recording this. We'll send out a link. We've got comments in the feedback that say thank you very much. And we also are going to send you a little, there should be a survey that's going to pop up and ask you for feedback to Marin Humane about this type of topic and workshop. So we appreciate any feedback you can give us. And with that, everybody have a great day and start planning.